Thank you.
So
All
you don't have to worry about it.
right, you're on.
Well, thank you for having me here today. I appreciate the opportunity and hope that I will be able to be a valuable resource for you. My goal is to educate you on why estate planning is important both for you and your family, especially if you are a business owner. Some of you may have heard my presentation before, and I still encourage you to listen till the end. Science has proven that we learn through repetition, so you may think you know everything about what I'm going to say, and I can assure you that you probably don't. And there's nothing wrong with that because sometimes I surprise myself. I don't even know everything I'm going to say. My mission today is to talk with you primarily about the three biggest myths about estate planning that everyone needs to know. I knew someone named Alexa who fell prey to these myths, and she quickly realized what she had done and she turned it around and made good for herself. She was a business owner. She happened to be a lawyer, and she had married her husband, and they had been married several happy years, had several children. She had a prospering business and had nothing, no estate plan, no protection for her kids or her business. One night they were out on date and she had a brain wave. You know how you get those brain waves and it's just like, oh my gosh, how did I not think of this? In her case, it was, Jim, what will we do? We don't, what would we do if we never came home this evening to our kids who are with a babysitter? And she was just flooded with fear. Fortunately, she knew what to do. Jim thought this is a total waste of time, but she was firm about it and created an estate plan. She knew that you are never too young, you are never too poor, and you can always find a way to make the investment to create an estate plan. It is much less of an investment of time and money for you now as it would be for your family if you did not have one. And I'm going to go through all of these in order. The first myth, which I've heard from many clients, I'm not rich enough to need an estate plan. This is something that surprised me the first time I heard it. I heard it from a woman who had her own home. It was an asset that she owned. It was valued at $250,000 approximately. She also had her own business, and I don't really know what the value of that was, but the business itself owned a building, which has a huge value. It also had a fairly large client base, and there were a lot of, the profits were pretty good. So she had a lot of assets there as well, and she was the sole owner of the business. It's very easy to accumulate assets without even really thinking about it. Even if you rent your home or your business um, buildings, you still have assets in the form of bank accounts and personal property and other household items that are part of your estate. An estate is just a container that holds the assets. It's a legal fiction. It's not a fiction, but it's one of those terms of art that kick in whenever someone dies. Whenever anyone dies, the clerk of court opens an estate. It doesn't matter how much or how little you have. So you're never too poor to have an estate. And it's never too early to make an estate plan, unless you're a child, of course, under the age of 18. That's, that would be kind of against the law. Um, for this reason, I have created a one of the things that makes me unique is that I have created plans and packages that specialize in families who have assets and may go through several transitions during their lifetimes. Since you're never too young, I have a lifetime plan, which is especially designed for families who have children who may grow or change and who may go through a lot of transition. I can also help small business owners figure out what they want done with the business. And sometimes it is put in the estate plan. Sometimes it is a separate agreement depending on how the business is owned. There are other parts to an estate plan that are fairly important. It's not just about a will. It is also about what will happen if you become seriously ill, and also about what will happen if you cannot control your finances. Now, this is something that people say, I'm not old enough to be in that position yet. I'm not old enough to need an estate plan or any of those other power of attorney documents. You know them by that name, even though they have nothing to do with attorneys. But I don't need any of that. I'm not old enough. Well, you know, disaster can strike at any time. Cindy will tell you that insurance is necessary to avoid a disaster. I would submit that financial organizing and estate planning are also necessary to avoid having a disaster impact you in very unfortunate ways. If you become seriously ill, let's say you're in a car accident, for instance, and you cannot make decisions for yourself, you are unable to make healthcare or medical decisions, the doctors will do their best to treat you, and they will treat you according to what they're allowed to do. However, if there is a question about the type of treatment that you want, there is a myth that says, oh, my husband will just decide. No. Unfortunately, the law in this case values individual freedom so much that you are the one who is in control of your own body and your own personal dignity. That's the principle. And therefore, no one but you can decide on some courses of treatment. Now, I can't tell you, I mean, I'm thinking of life support, but there are other examples. Serious surgery, for instance, that would be life saving surgery, maybe. And the doctor says, we're going to do this surgery because it will save her life. And your husband knows you wouldn't want it for some reason, maybe whether it's a religious issue or something like that. The hospital in advance was not able to get you to sign an agreement giving your husband the authority to speak for you, which they can do. But since you came in, serious catastrophe, they weren't able to do that. And so this is still your decision, and no one else can speak for you on it. Um, and so you are never too old to need these documents. There's a myth that says, well, I don't need them until I can't understand what's going on around me. And that's just, unfortunately, not the case. The second reason you would want powers of attorney, especially in a financial case, is if you're missing. You decided that you wanted to go on a trip to Antigua and you left and didn't tell anybody about it, or rather, maybe you told someone about it, but you're still gone and it's been like 2 months. Well, the bank needs something done, and they can't do it. Let's say your water bill was due, and for some reason there was a problem with your account and the draft did not go through. Well, now everybody is stuck because no one has the authority to make financial transactions for you, and they can't find you. So that is another reason why those documents are very important. If you are missing or detained, someone else can take over for you and do the things that need doing. The third myth is that this estate plan will cost too much money. I can't afford doing it. It's just too much. I'm going to put it off. I don't even want to deal with it. My family will handle it once I'm gone. The court has a process for that, and they'll just do that. Well, it is true. There is a process called probate. So if you die without a will, it's called dying intestate. The feudal system from the Middle Ages kicks in, and the feudal system says, okay, you died without a will. That means the clerk, number one, opens an estate, just like I said before. And number two, tries to find out who is related to you by blood and distribute assets to them in various proportions. Your spouse gets next to nothing. They can claim an elective share of $50,000 or a life estate in the house that they live in now, which means they can live there for their life, but nothing else from you. So it is a myth that my spouse will inherit what I have. That's really not true. And, I just won't deal with it. So according to the feudal system, it's basically by blood, people inherit what you have. And there is another problem. There is a probate tax. The probate tax, if you just have a will and no trust, and or you have no will, the probate tax is involved because everything goes through probate. And the tax in North Carolina is 4%. It may not sound like much, but let's pretend again you have a home, $250,000, you have some cars and some assets. You may even have a business with some assets that you have a personal interest in, and you did not have a sales agreement or anything. And your interest is part of your estate, so it's an asset. And the value of that is, I don't know, $400,000. Let's just pretend. The probate tax for that $400,000 is $16,000, just taken off the top before anyone gets anything. There is a way to protect your estate from being taxed by probate, and that is by creating a trust, which is simply a container to hold your assets after death and to have them automatically go to people that you intend to have them. It's a little bit different than a will. There's a little bit more oversight in terms of people that you know and trust. That's why it's called a trust. People that you trust will be making sure that everything goes where you want. And if you set up a trust in addition to a will, it's a little more money to do that initially. However, I submit that it is a great investment because you avoid the probate tax. Now, the attorney might charge you, $4,000 and up to create your entire estate plan. The probate tax is $16,000. So I would submit that it's better to pay $4,000 now, save your family years of stress during the probate process after your death, and get all of this done. So although it is an initial investment, you will not be subjected to that tax, and you will save $12,000 or so and a bunch of stress. Your family will save a bunch of stress and emotional heartache. Not only are they grieving your death, but they're having to navigate the court process. And this matter of probate is very public, and that's also very hard to deal with. So peace of mind is a good thing to give them. Those are, in a nutshell, the 3 myths of estate planning. I would submit you are never too young. You have enough, and you have enough time and money to get that plan created. So a good attorney's job is to guide you through this process. And I said I would talk about small businesses, and although I touched on that, it will have an impact on your business, and depending how your business is organized, the impact will differ. For instance, if you have a limited liability company, you will be liable to the extent of your capital contribution. If you have a partnership, your interest will be according to the partnership agreement. If you die and you do not have a business agreement about what will happen to the business, the interest in the business, if it's a partnership, could just fall into the estate, and there could be a lot of confusion. So that is all I'm going to say about that, because it's very confusing. It's most important to know some generalities, and if you have businesses, your specific situation will determine a lot about how the business falls into the estate plan. So don't fall prey to these myths about estate planning. And attorneys such as myself are here to guide you through the process and help you protect your family and your business. So in my case, I can give you a free complimentary consultation. All I ask is that you fill out my enrollment form. I will put a link to that in the chat, as well as a link to schedule that consultation once the form is filled out. I invite you to fill out that questionnaire, and if you are interested, and we can move on from there. I am here to answer any questions that you all might have. I understand that this was a lot of information, and I'm here to help you sort it out. Thank you very much for having me.
Thank you, Erin.
Thanks, Erin.
Hey, Erin, I think you left out something that you do that I think is very significant. Which is,
Such,
oh,
such
yeah,
as?
that you offer free updating of those documents for the
No, I
life.
said it before. I said
Oh, I missed it
lifetime
then.
planning. Yeah, I did it at
Okay,
the
well,
beginning.
sorry then, I apologize.
That's okay. I'm glad that you remembered from last time.
Yeah, and I thought lifetime planning just meant planning for your life. I didn't connect the dots that meant. Honestly, neither did I. Yeah, I didn't connect those dots either. That you meant that you would be willing to read, like, in other words, say I got another grandchild and I now wanted to include them in what I was doing. I could reach out to you and you could adjust my will accordingly. Or I got divorced and I want to write him out of the will. You could just, like all the different things that happen, you would
Right.
adjust. I didn't realize that's what that
Yeah,
meant.
so the lifetime planning is basically lifetime updates for the documents you create in your original plan with me. So if you create a will and powers of attorney, they have lifetime updating. If you want to create another document, then that is a separate document. So it's not included, but it can be included. You know, I charge you for the document, and there's a extra little bit for the lifetime, including that in the lifetime plan.
It's still a big deal though. Because things
Of
are
course,
changing.
because life changes, yeah, life circumstances.
Because there are lots of changes in people's lives, and it's a better investment. I mean, there are attorneys, you can go to attorneys and they will update your documents and they'll charge you a fee to do that, but you could spend a lot of money. You know, fees vary, so I can't quote you an exact amount, but thousands of dollars. If you created your documents and you were young enough, you know, in your 40s, 30s, you could spend thousands of dollars getting updates over your lifetime. And you know, my lifetime plan is basically less than $1,000 to add on to whatever plan you are, you know, you're choosing.
So walk me through that scenario. What you're saying is if I've put together my documents already and I come to you.
I'm sorry, I can't hear whoever is talking.
Okay, so can you go through the process, the steps that you're talking about? So you're saying somebody already has put together their estate plan, and this is what you're offering is $1,000 to update for the rest of your life? Is that what you're saying?
I can't hear you, so I will repeat what I thought you said. And also I'm not sure, but anyway, I'll repeat what I thought you said. So your question was, if someone comes to me and they already have an estate plan created from another attorney, will I charge them $1,000 and then update it for the rest of their life? Is that what you're saying, asking?
Yes.
No. My to answer your question, that I would create an entirely new plan for you, and then we can talk about, you know, whether or not you want a lifetime plan or not. But if someone is coming from another attorney, I don't have a lifetime plan in place for that. I give you a whole new plan, because most of the time people come from another attorney. They haven't had their estate plan updated in donkey's years. I mean, 15, 20 years. And they want, and they need an entirely new plan anyway. I was saying something completely different. You come to me and have no estate plan in place whatsoever, which is the usual way that people come to me. Nothing. You ask me to help you, And we determine after the enrollment conversation that you will engage me for your services, and for my services. And after that is done, we also determine at that time what type of plan you need. There are several types. And once we do that, then there is an option for either a once and done, you get it done once and you go on your merry way, or you get it done and all the documents that are created are involved in a lifetime update process. So you get them updated for the lifetime of our work together, or for your whole life, or however long we are associated together. And it applies to me and you only. So for instance, if I decided after 20 years I was no longer practicing this type of law, and I would come to you and say, I'm no longer practicing this type of law, I will refer you to my friend over here that I know, like, and trust, and it will be up to you to engage her services, and I make no guarantees that she will accept the lifetime plan. She has her own business and the way she does business, so she might not accept that. So it's your life or our association together.
Okay, thank you.
Hey, Erin, it's Cindy. How are you?
Good.
Hey, I have a question for you. So my mother lives in Virginia, and we're really trying hard to get her to move to North Carolina. If she does an estate plan in Virginia, would she have to change anything when she moved to North Carolina, or would that still stand?
Well, the estate plan is valid according to the law of the state where it was created.
Okay.
So she wouldn't have to change anything. It's just that when she dies, Virginia law applies.
Okay.
And so you would need a Virginia attorney to help you.
Okay.
Erin, which states are you licensed to practice law in?
I am licensed in the state of North Carolina.
Can you add yourself to other bars, or you're have no interest in doing that?
I am not interested in doing that at this point. Number one, I can't afford that. And number two, not all states have reciprocity. So for instance, I would have to take the South Carolina bar and Virginia bar. I already know that.
That sounds like a terrible idea. Never mind.
Why can't I hear anyone? I'm sorry, I didn't hear what you said.
I said, that sounds like a terrible idea.
Yeah,
Can
the
you hear
mic
us
did
now?
go.
Can you hear us better now?
Yes. Yeah, I can.
Well, I bought a very expensive microphone, that was not working well.
Of course not, because it's expensive and it's fancy, so it doesn't work as
And it's
well.
got colors that go around. It's very pretty though. You would find it quite remarkable if you could see it.
I assume so. Are there any other questions I can answer?
Yeah, Erin, I have a question. Maybe I wasn't following what you were saying before, but if I do an estate plan here in North Carolina, but say move to South Carolina, is it no longer valid?
No, actually, that's not what I said. I'll
Okay.
say it again because it is
I was
confusing.
wondering that.
Yeah,
Yeah.
I'll give you an example. So I had a client who was in Maryland, and her mother lived in North Carolina. Her mother had a will that was from Maryland. No, wait, hang on. I'm getting confused. The client was in North Carolina. The mother lived in Maryland and had a Maryland will. My client was the administrator for her mother's estate. And so she was only my client briefly, and it was on another matter. But I had to tell her, you have to contact the Maryland court in whatever county it was, because your mom's Maryland will is valid, even though she had lived here in North Carolina briefly, the mother. So you move to another state, your will is valid in the state that it was made in. And that doesn't mean that it can't be enforced. It's just that you have to go back to that state. And their laws about probate and taxes and everything are the ones that control.
So if I moved, in order to avoid that complication, if something happened, I would need to somehow transfer it to my new state.
You can't do that. I mean, you can't
Oh,
you
can't,
can't
you have to
amend you
redo
can't
it?
amend a will to say that I want another state's law to apply. And that goes with all the other documents that are part of an estate plan. You have to create new documents because each state has different laws.
Wow.
If you are, I mean, it doesn't really matter that much. You just have to know that whatever state your documents are created in is the one that controls for distribution of assets and tax purposes when when you die. And if you become ill or something and you have to use the power of attorney documents, they're valid. You can still use them, but they may look different or be somehow different because they were created in a different state and that state's law applies to them.
Do the states vary that much?
A lot of variance, not so much with the power of attorney documents, but definitely with probate and taxes. There's a lot of variation on probate and death taxes. North Carolina, for instance, is very friendly. There is the 4% probate tax. It does not, however, have an estate tax, an additional estate tax after death. Some states have, like Florida, it's crazy. It's like 10% or something on top of whatever their probate tax is. So in those states in particular, trust planning is very important. But the will is where those differences show up most prominently because of the taxes.
Do you advise us investigating which state has the lowest taxes and getting a will in that state, or that's silly?
No, I wouldn't do that.
Okay.
Because you have to get a will in the state where you're, I mean, if you write an initial will, it should be done in the state where you're living.
Okay.
So my mother has property in the state of Indiana and in North Carolina. That being the case, if her will were to include both states, will she actually have to have her will also in Indiana banks and in the actual county where her mother's house is?
Can you hear that, Erin?
Well, she has a deed in that county that she owns the house, right?
Yes.
Yes,
The
she's
will
a third
doesn't, the will doesn't need to be, nothing needs to be done with the will until her death, at which point the will is executed. So if the will is here in North Carolina and it's executed, which means it takes effect upon her death, goes into probate, and the will has provisions in it about the property. I want my son to inherit my Indiana property. So the son inherits the property, and since North Carolina law governs probate of the will, then North Carolina law applies as far as distribution of the property, how it's actually done. Wherever she lives, wherever the will was created, that state's law applies. It doesn't matter if property is in another state or not.
Okay. Thank you.
Mhm.
So when you said, so Erin, when you said that North Carolina has no estate tax, are you talking about inheritance tax or explain estate tax?
So estate taxes are those taxes that are assessed against an estate based on above and beyond probate. And some states have higher taxes than others. And so when I say estate tax, I actually do mean inheritance tax. It's called both things.
Okay.
The inheritance tax for North Carolina, most people won't, it doesn't have one. there is a federal tax. And in order to be subject to that federal inheritance tax, you must have assets of, if you're a single person, $5.5 million in total. If you are a married couple, it's like 11.5 million. It's absurd. But a lot of states have inheritance taxes, like Florida or California or other states, on top of that federal estate tax, and their numbers are a lot lower. Like you have to have, I don't know, $750,000 in assets, for instance, and their estate tax will kick in, whatever percentage it is, their inheritance tax.
Okay, thank you for that clarification.
Mm-hmm.
Isn't it true that if there's a husband and a wife and one of them dies, the spouse doesn't pay that estate tax? It just goes to the survivor? Is that true?
No, not necessarily. It depends on how your estate plan is set up. So if your estate plan is set up and it is a will-based plan, then everything goes into probate and it is administered and distributed according to probate. And there is a probate tax in North Carolina. If you have a trust-based estate plan, then what you just said is actually what happens after creditors' claims are satisfied.
So even if you have a will establishing that you want everything to go to your spouse, it still has to go through probate?
Yes,
And there's still a
absolutely.
4% probate tax.
Mm-hmm.
All right, I'm gonna belabor the point. If a man and a woman own a house and both names are on the deed, and a man and woman have a checking account and both names are on the checking account, those assets still pass through probate, even though they're jointly owned?
The assets are jointly owned,
Yes.
and what passes through probate is the spouse's interest in those assets. So, and it's not so much the house, but sometimes with the bank accounts, there will be some there is going to be some probate involvement because the spouse actually has an interest in the assets, and there may also be some other things that they're distributing. And so it's all going to pass through probate, and nothing may happen. It just may be, this is how we've recorded that we want this done, and these are the ways in which it's going to be distributed. The administrator just may have to file a couple of inventories, and it may actually not take that long in the case where everything is jointly titled. But the probate process still does get involved.
Anybody else have any other questions?
So it sounds like it would be better to have a trust than to have a will. Yeah. Is that accurate?
It is accurate. It is not, it's one of those things that it's like, it's not necessary, but it does save some time and money at the end. It does, it is rather helpful.
So.
I was gonna ask,
Go ahead.
if you're going to start with one piece, what is the most important piece? Is it the will, or is it the trust?
I would start with the basics, a will and your power of attorney documents. Those protect you in life. They are essential. So I would start with the will and the documents for power of attorney, your advance directives. If you have children, though, you need to have a trust because, as well as some other documents about guardianship, because your children need to be protected by the people that you designate, and also the guardian needs to have access to the financials, to some of your assets. And
What if your children are adults?
that's not as necessary. You don't need that if your children are adults. You just need, basics. If you want to do the basics, the will and the power of attorney documents. If you decide you want a trust, if you have a lot of assets that aren't joint, for instance, and you decide that a trust is really necessary, or you want to put a trust in place in case your spouse, you both are going to grow old together and die happy, and one of you dies first and your spouse is not going to be able to manage the assets because of her age or illness, and you want to contemplate that, then you would want to trust. I mean, this is something that's going to be specific to your situation. So I really can't say 100% for certain what you need without talking to you and giving you advice based on your own personal needs. So this was intended only to be, general advice only. Does that answer your question?
Yeah, thank you very much.
Mm-hmm.
Can I just clarify also that the 4% probate tax applies to your entire, all your assets, including like 401k and all of the assets?
That is a very good question. It does not apply to assets that transfer outside of the estate. It does not apply to, for instance, many of the assets that have beneficiaries already designated, like life insurance policies, for instance. Unless you make provisions for that, they generally do not pass through probate. They pass directly to the beneficiaries.
Okay, thank you.
Thanks for that clarification. Erin, it was very wonderful for you to come onto our meeting and talk to us about these 3 myths, because obviously there is a little confusion with them. And as I always say, it's better to be prepared,
Not scared.
not
There you go.
scared, as Tina would say.
Stealing the line.
So I encourage all ladies to reach out to you if they are interested in talking with you in more specific in your situation.
And I am putting thank you very much. It was my pleasure to be here. I am putting my information into the chat window. So if you would like to reach out, please feel free to do so by email, for instance, Erin@erinedgarlegal.com, or you can call me, or you can just go ahead and fill out my form. You have all kinds of choices, and I would be happy to talk with you some more.
Okay, thanks, Erin. We do appreciate it.
Thank you.
Okay, I have stopped recording, and we are now at the portion of the meeting where if you feel you need to do or have any announcements or accolades, we can go